Ready? Start. Through the judgment of the partly allowed rate petition filed by Vast Media Network Private Limited, Director Abhijit Rane, delivered on June 19, 2025, against the state of Maharashtra and others, Chief Justice Alok Aradhe and Justice Sandeep V. Marne at the Bombay High Court in Mumbai have set aside the allotment of lease of central store office in favor of the respondent for Nitin Lakshmidas Dama, and the tender process initiated wide notice of July 24, 2024 is restored qua the central store office, since the petitioner and respondent for have quoted some rate of rupees 75 per square feet per month. As per the High Court directions, the respondent's State Dairy Development Department Chief Executive Officer RA Milk Colony and the Commissioner Dairy Development Mumbai shall allot lease in respect of Central Store Office to the entity offering higher rate para, except the petitioner and the respondent for Nitin L. Dama. No other bidder shall be entitled to participate in such renegotiation process para. The High Court has stated further that till the fresh decision is taken for allotment of lease in respect of Central Store Office, respondent for Dama shall continue to hold possession thereof in the event of respondent 123 taking decision to allot the lease in respect of Central Store Office in favor of the petitioner. The respondent for shall forthwith vacate the possession of the Central Store Office within 2 weeks of the decision of the respondents 123 para. This petition has been filed to seek cancellation of the tender process in pursuance of tender notice of July 24 issued by respondent 123 for grant of lease of 16 warehouses and central store office for tenure of 30 years para. Petitioner is aggrieved by non-allotment of central store office to it, even though its financial bid is identical that of respondent 4. It is aggrieved by the action of the tendering authority in applying the preference clause in the tender notice, providing for preference to bidder applying for higher number of warehouses, which according to the petitioner applies only in relation to warehouses and not for the central store office para. What is also pertinent to note here is that the bidders were granted liberty to submit bids for either one warehouse, some warehouses, all warehouses out of the 16 warehouses. Thus, the right to apply for more than one premises was restricted only in respect of 16 warehouses, thereby drawing a conscious distinction between warehouses and central store office para. The list of 17 premises also clearly made a distinction between 16 warehouses and central store office. The clause of security deposit only applied to the 16 warehouses and not to premises number 17 in the list, namely central store office para. In the court's view, therefore, the petitioner has rightly contended that the preference clause in paragraph 4 bracket 4 only applied to bidders in respect of the 16 warehouses, and the same had absolutely to connection with implementation of tender process regarding central store office in the opening paragraph of the tender document. Therefore, in the court's view, the action of the tendering authority in giving preference to respondent 4 only an account of his submitting bids for 8 warehouses plus central store office over the petitioner is clearly arbitrary, irrational, and against the tender conditions para, while holding that the decision of the tendering authority in granting preference to respondent 4 by application of condition number 4 in bracket 4 to be arbitrary and irrational. The High Court is conscious of settled position of law that the interpretation of the tendering authority is final and binding on bidders. However, the present case does not involve two possible interpretation of clause 4 in bracket 4 para. Application of preference clause 4 subsection 4 to bidder applying for allotment of central store office is clearly erroneous since the tender conditions are clear and unambiguous. In High Court's view, clause 4 subsection 4 had no application while allotting the central store office premises, which is clearly distinct from the 16 warehouses as per the tender document itself para. Since the petitioner and the respondent have quoted same rate rupees 75 per square feet, the tendering authority could have entered into renegotiations with both the bidders and ought to have allotted central store office only to the bidder offering higher rate. For taking the High Court has derived support from the Supreme Court decision in the case of Ram and Sham Company versus State of Haryana and others 1985 3 SCC 267.